Be ready. Start. The principles governing the sentencing policy in our criminal jurisprudence have more or less been consistent right from the pronouncement of the Constitution Bench judgment of this court in Bachchan Singh versus State of Punjab. Awarding punishment is certainly an onerous function in the dispensation of criminal justice. The court is expected to keep in mind the facts and circumstances of a case, the principles of law governing award of sentence, the legislative intent of special or general statute raised in the case, and the impact of awarding punishment. These are the nuances which need to be examined by the court with discernment and in depth. The legislative intent behind enacting Section 354(3) CRPC clearly demonstrates the concern of the legislature for taking away a human life and imposing death penalty upon the accused. Concern for the dignity of the human life postulates resistance to taking a life through laws, instrumentalities, and that ought not to be done save in the rarest of rare cases unless the alternative option is unquestionably foreclosed. In exercise of its discretion, the court would also take into consideration the mitigating circumstances and their resultant effects. The language of Section 354(3) demonstrates the legislative concern and the conditions which need to be satisfied prior to imposition of death penalty. The words, in the case of sentence of death, the special reasons for such sentence unambiguously demonstrate the command of the legislature that such reasons have to be recorded for imposing the punishment of death sentence. This is how the concept of the rarest of rare cases has emerged in law. Viewed from that angle, both the legislative provisions and judicial pronouncements are at ad idem in law. The death penalty should be imposed in the rarest of rare cases, and that too for special reasons to be recorded. To put it simply, a death sentence is not a rule but an exception. Even the exception must satisfy the prerequisites contemplated under Section 354(3) CRPC in light of the dictum of the court in Bachchan Singh. The Constitution Bench judgment of this court in Bachchan Singh has been summarized in para 38 in Machi Singh versus State of Punjab, and the following guidelines have been stated while considering the possibility of awarding sentence of death. Life imprisonment is the rule and death sentence is an exception. Death sentence must be imposed only when life imprisonment appears to be an altogether inadequate punishment having regard to the relevant circumstances of the crime and only provided the option to impose sentence of imprisonment for life cannot be conscientiously exercised having regard to the nature and circumstances of the crime and all the relevant circumstances. We have previously noted that the judicial principles for imposition of death penalty are far from being uniform. Without going into the merits and demerits of such discretion and subjectivity, we must nevertheless reiterate the basic principle stated repeatedly by this court that life imprisonment is the rule and death penalty an exception. Each case must therefore be analyzed and the appropriateness of punishment determined on a case by case basis with death sentence not to be awarded save in the rarest of the rare case where reform is not possible. Keeping in mind at least this principle, we do not think that any of the factors in the present case discussed above warrants the award of the death penalty. There are no special reasons to record the death penalty, and the mitigating factors in the present case discussed previously are, in our opinion, sufficient to place it out of the rarest of rare category. For the reasons aforementioned, we are of the opinion that this is not a case where death penalty should be imposed. The appellant, therefore, instead of being awarded death penalty, is sentenced to undergo rigorous imprisonment for life. Subject to the modification in the sentence of the appellant A1 mentioned herein before, both the appeals of the appellant as also that of the state are dismissed. The above principle, as supported by case illustrations, clearly depicts the various precepts which would govern the exercise of judicial discretion by the courts within the parameters spelt out under section 354(3) CRPC. Awarding of death sentence amounts to taking away the life of an individual, which is the most valuable right available, whether viewed from the constitutional point of view or from the human rights point of view. The condition of providing special reasons for awarding death penalty is not to be construed linguistically, but it is to satisfy the basic features of a reasoning supporting and making award of death penalty unquestionable. The circumstances and the manner of committing the crime should be such that it pricks the judicial conscience of the court to the extent that the only and inevitable conclusion should be awarding of death penalty. In Machi Singh and others versus State of Rajasthan 1983 3 SCC 470, this court stated certain relevant considerations like the manner of commission of murder, motive for commission of murder, antisocial or socially abhorrent nature of the crime, magnitude of crime, and the personality of the victim of murder. Thank you.